Hello friends, Patrick McFarlane here with another edition of Liberation Library Book Reviews on the Liberty Weekly podcast. The show notes for this episode may be found by navigating to libertyweekly.net/LL3 for Liberation Library 3. As well, the video version of this book review will be available on my YouTube channel at youtube.com/libertyweekly. And today we are not actually reviewing a book. We will be reviewing a law review article that I've used in my own research, again by William J. Watkins Jr. I'm kind of returning to my roots here, talking about things that maybe aren't necessarily to do with voluntarism or abolishing the state, but rather talking about judicial things, legal things, things working within the state, within the constitutional parameters that the Founding Fathers set forward in an effort to limit the federal government in its creation, a task that obviously has failed, unfortunately. But nonetheless, we're going to return to the roots of what our government was supposed to be in an effort to perhaps understand it a little more, understand how it was corrupted and allowed the government that we have today, but also to see how we can use it to maybe try and fight defensively, mind you, in a limited political sense, defensively, to try and limit the government using, of course, what was set forth through the parameters of the Founding Fathers. So in this episode, I'm going to be talking a little bit about popular sovereignty, theories of sovereignty, but also, as the title of this law review article would denote, Judicial Supremacy and the American Revolution, and why the judiciary cannot be the final arbiter of constitutions. And I'm going to be reading a little bit here just from the introduction, just to preface this. So William J. Watkins Jr. begins here by saying, "The development of constitutional government in Great Britain and America is inseparable from the debate and the conflict over sovereignty. And in Britain, parliamentary sovereignty triumphed over the divine right of kings to form the foundation of British liberty." And just a little note on that, so throughout British history, the king was known as being the sovereign in the country. Originally, it was divine right of kings. So the king manifested the sovereignty. Basically, whatever the king said was the law of the land. And that evolved throughout the centuries, basically because the king found out that he had to rely on Parliament and his meeting of the lords in order to fund his wars, because he needed their cooperation just de facto in order to do whatever he wanted. So it became to be that, well, it's not just the king that is the divine sovereign, it is the king acting with Parliament that is the sovereignty within the country. And then, as he continues here, that kind of evolves, and now it's parliamentary sovereignty evolved, whereas it was the people's will acting with Parliament that was the ultimate law of the land within Britain. But then, as Mr. Watkins continues here, he says, "In America, popular sovereignty," that's the addition, or that's the new theory of sovereignty that was developed throughout the American Revolution, and as the colonists were grasping for any kind of legal basis with which to fight what they saw as unfair acts, unfair constitutional acts within the British system that were taxing them unfairly, as this article kind of denotes. Actually, interesting story, through this article, William J. Watkins Jr. kind of identifies the fact that when Thomas Jefferson was reaching for legal authority with which to argue against the unfair taxation, you hear taxation without representation. Well, they were being trampled by the Parliament in the United Kingdom, and it's not that the colonists were unrepresented in Parliament in the United Kingdom. They were represented virtually in Parliament, but they were not represented by delegates that were actually from the colonies. So that was their quibble. They were represented just virtually. And interestingly enough, in this article, there's just the fact that Thomas Jefferson was appealing to King George to come in and try and assert his divine authority, divine right of kings, more of his executive authority to overrule these taxation. And that's a very interesting part of history that I learned through reading this article. I also want to note that there might be some factual discrepancies in what I say. It's been a while since I've read this, so this is what I remember, is that without actually going back and reading through the whole thing, that note about Thomas Jefferson, but I'm pretty sure that that's in these pages here. But just to continue with the idea, I'm getting sidetracked, but of popular sovereignty. So he continues, in America, popular sovereignty triumphed over parliamentary or legislative sovereignty to render government the servant of the people. So that's the idea. Without acceptance of popular sovereignty, judicial review would likely be unknown in the United States. And judicial review is the idea that the judiciary has the power to strike down laws that they deem are unconstitutional. Now, under parliamentary or legislative sovereignty, the legislative body exercises ultimate authority over statutory law and fundamental law. The legislature can make or repeal law as it sees fit. With the exception of revolution, neither the judiciary nor the executive nor the people can override the legislature's will. Under popular sovereignty, the executive, legislative, and judiciary are mere agents of the people and the people's constitution. In performing their constitutional functions, the branches must interpret the Constitution to ensure that their actions conform to the instrument. In the judicial context, a court must compare a statute in controversy with the text of the Constitution before giving effect to the statute. For example, if a constitution secures the right to trial by jury in all civil actions where the amount in controversy exceeds $100, and the legislature passes a statute increasing the jurisdictional amount to $500, a non-jury verdict for $400 would be void if one of the litigants had demanded a jury trial. The judiciary would be bound to declare such a judgment a nullity on the grounds that an act of the legislature cannot alter the people's fundamental law. Sorry, that was a bit of a mouthful, but you get the concept here. So what we're seeing and what I wanted to kind of address was the place that judicial review has taken within the conservative narrative. So within circles and certain people involved with perhaps the Mises Institute, and I'm not naming specific names, although I will mention Brian McClanahan, because I had a little quibble with something that he had said in this book that I've used. And this is not a book review of the Founding Fathers' Guide to the Constitution, but rather there is a lecture that he did on Marbury versus Madison, which is the seminal case that decided this question of judicial review. That's what we learn in school. That's what we've learned in law school. It is the case where John Marshall, the third, I believe, Chief Justice of the Supreme Court, kind of seizes the power of judicial review, and obviously it kind of runs away from there. But there is a narrative, and I'm not saying that Brian McClanahan has presented this narrative, but there is a narrative in certain circles that this was completely wrong for John Marshall to do, and that the Supreme Court that he used the power of the Supreme Court to seize judicial review and to make it a thing. And from there, it kind of evolved. And while John Marshall was a very destructive force when it came to the constitutional safeguards, I wanted to assert the point that judicial review is not out of left field. Judicial review is, and Brian McClanahan kind of agrees with that point in this book. And I wanted to find the exact point where he said it. He says on page 144 of the Founding Fathers' Guide to the Constitution that the record of the Philadelphia Convention and the state ratifying conventions illustrates that the founding generation believed the Supreme Court would have the ability to void federal legislation, meaning judicial review. meaning that judicial review was not fabricated out of thin air. However, the court's ability to declare state law unconstitutional is a bit murkier because the majority of the founders opposed it, except in a very limited sense. And so you see Brian McClanahan is saying, well, judicial review didn't just come out of nowhere. And he's correct here in saying that, although in the Liberty Classroom lecture, he seems to say, and I'm doing this off of memory, so apologies if I'm misconstruing his statements, but he seems to say that John Marshall seized the power of judicial review and did so outside of the power that he should have, or some such. And this law review article by William J. Watkins Jr. is really good. It's just amazing. And like I said, it kind of details the evolution from British history, the history of this idea of sovereignty. And this is kind of a Western concept, but sovereignty is essentially, and I mentioned this in episodes of the podcast before that I've linked in the show notes page, but sovereignty is essentially the ultimate decision-making power within a certain society. And like I said, popular sovereignty is the idea that the people themselves are the ultimate authority. And I would assert individual sovereignty, that an individual is the sovereign of himself or herself and his property. But this law review article, returning to that, is very good at detailing the state common law development of this idea of judicial review before the ratification of the Constitution, and moreover, after the ratification of the Constitution, how state courts dealt with these issues, even after the ratification. So it details what has been described here and delineated as the clear case doctrine. And the clear case doctrine is essentially just when the state courts had an issue, they were perhaps examining a law passed by the state legislature and comparing it to the state constitution. And in these instances, they have delineated the rule that if a law clearly violates the Constitution, if it's kind of a no-brainer, then the court has a duty to declare it unconstitutional. That's part of, what they do. But you're getting into, and this is dangerous waters, because when you get into that question, you sometimes run afoul of politics, and the judiciary is supposed to be nonpartisan. Well, we all kind of know that's pretty much a joke, but the state courts realize this too. And in fact, if the law, if it was questionable as to whether or not a law violated the state constitution, the state court common law decisions leading up to Marbury versus Madison articulated that a close law was a question to be sent back to the legislature for review. Either sent back to the legislature or the judiciary should just leave it alone, because this was an issue not for the courts to decide. It was a political issue that should be decided by the public or by the legislature. And that's an important case, and I think that we see this a lot of times in the Supreme Court these days. You get super duper politically charged questions like, abortion. Does abortion violate the Constitution? Well, this obviously is something that should not be left to the courts to decide. And you have other things, because it's so contentious, because who the hell knows? I think that a lot of what the Supreme Court does is very arbitrary. And if you get into the 14th Amendment law, talking about, what is a fundamental liberty interest? And if the court, through what I think is rather arbitrary, decides that a liberty interest is, I forget the particular language, but if it's so important to our established tradition of what is an essential right, then the law, in order to pass the 14th Amendment, has to meet strict scrutiny. Well, if it's just like a liberty interest, like if a gender is being discriminated against or something, in quotations, then it doesn't have to meet such a burden, And when I say strict scrutiny, it also has to be narrowly tailored to the interests at play. So if a law is created that infringes on a fundamental liberty interest, then the law has to meet strict scrutiny, which means that it is absolutely, narrowly tailored to just for the specific purpose of, a fundamental governmental interest. And this is kind of a sidetrack, but that's what 14th Amendment law is. And in my opinion, from what I've learned about it, it seems pretty arbitrary. And I just think that, these are political decisions that are not for the court to decide. And that is actually almost the entire 14th Amendment, like equal protection and stuff like that history. And I digress because I've kind of gotten off topic here, but I hope that my input has been interesting on the Supreme Court. I think that the question of judicial review is very important, and I think that to kind of sum this up, that the question of judicial supremacy, of judicial review is super important, and we've completely abandoned that question of the clear case doctrine. And I think it would be very helpful for us maybe to recover that. I know this is what we have in the Supreme Court today is a far, far cry from what maybe the founding fathers envisioned, I think, because we have a council of oligarchs that will dictate policy for the entire nation. And obviously that isn't working. People in all the 50 states are very, very different, and they should have the self-determination to decide what policy fits within their state. And yes, this might create some despotism in certain states, but it also might create the possibility for liberty. And I think that's something that we should support defensively. And I think that the Anti-Federalists and the Jeffersonian Democratic Republicans understood that too. So I know I've kind of rambled a little bit here about, my opinions on the court, on the Supreme Court rather. But I would definitely recommend here, this is a law review article, and I've printed it out for my own researching, and it's gotten kind of affected a little bit from being in my backpack and stuff. For those listening to the podcast, I'm holding it up here for the camera. But I think that, if you're really interested in the Supreme Court, you're really interested in these kind of questions, this is an in-depth article, but it is a very, very good resource for understanding the common law that led up to Marbury versus Madison. And I would definitely recommend it. 10 out of 10 would read again. So, this has been another edition of the Liberation Library Book Reviews, or law review article reviews. I forgot to mention this is the Duke Journal of Constitutional Law and Public Policy. I'll include a link in the show notes page for you guys to all check out, and hopefully for your studying. Also, you can, just in closing here, you can follow the Liberty Weekly podcast by subscribing on iTunes, Stitcher, Google Play. All those links will be in the description below. The best way to help out the show is to spread word about the podcast, about this YouTube channel, and there's my cat Timmy. So, alrighty, well, this is going up, like I said, on my website at libertyweekly.net/LL, the letters 3. This has been Patrick McFarland signing out. Have a good week, everybody.